service. As a niche law practice, we are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We work with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Solicitors in Tottenham, on the 4th floor of the Anna House, right on top of the Victoria Line train station, for your utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks. Law Society accreditation helps to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. BWF Solicitors, we're here to help you with your legal services when you need us.
Victon Estates provides professional and reliable service to landlords, investors, and tenants. Our mission is to ethically and honestly serve our clients. We won't make promises we cannot keep, rather. We present a clear picture of the reality we can offer. We are here to help you with long and short-term let, property management, cash buyers for quick sales, stop repossession, and mortgage arrears. For all your property needs, look no further. Visit us at www.victonestates.co.uk or call us on 07448619711. Victon Estates, your property is our pride.
Hello everyone, you're welcome to Heritage TV, the BWF Legal Hour with Mrs. Lawyer Eunice Achampong. Today's topic is children under 18 applying to join their parents in the UK. If you want to contribute to the program, you can send your questions or contributions to our Facebook pages at Heritage TV and BWF Solicitors Facebook page. We are live on all our social media handles. And if you want to call us live in the studio, the number to call is 0744 8619 711. The number again is 0744 8619 711. And of course, this program is sponsored by Victon Estates Limited, your number 1 property management company in the country. You can contact them on info@Victon Estates and BWF Solicitors. They are also sponsoring this program, and we appreciate them for making it possible for us to come your way. Lawyer Eunice?
Hello.
Hello. You're welcome to the Legal Hour show. How have you been doing?
By God's grace, so I'm doing well. And how about you?
I'm fine, thank you.
Good.
Looking forward to today's topic.
Yes.
I think last week topic involved children. Am I right?
Yes, it did. Yes.
And this week's, today's topic is also centered on children.
Yes.
So before we go into this topic, as we always do every Saturday, have you got any updates for us?
Yes, I do. I think that we're not going to ever get finished with our EU applications. I think this is something that is going to be here for quite a long time. And so I want a lot of people to be aware that if they have made any EU applications previously to the 31st December 2020 deadline, and for one reason or the other, they made the applications for extended family members or their close family members to join them here in the UK, and the application may have been refused. Of course, they would have a right of appeal. And if they have appealed, usually the cases are dealt with at a hearing in court. And if the judge sees fit and allows the appeal, then of course it is up to the Home Office to have a way of, shall I say, appealing the decision of the judge within 14 days or within 28 days, depending on whether the person who made the application was in the UK or outside of the UK. And most of these applications were for people to join their family members from outside the UK. And so you would realize that quite a number of people who have had their decisions allowed in terms of their appeal decisions, ongoing appeals obviously are still ongoing, but for those that have received decisions to allow the appeal, you will have messages from the Home Office in terms of emails saying that, of course, they know that the decision was allowed, but of course, since the 30th of June, the EA family permits are no longer valid, or they are not seen to be valid in terms of leave to enter into the UK. And so it means that anybody who was granted an EA family permit, or anybody who has appealed a decision, which is an EA family permit decision, and has basically not been given that EA family permit to travel into the UK, they are basically saying they would no longer issue such a permit. And therefore, even if the appeal has been allowed, because the permit will no longer be valid, there is no point in issuing the permit in the first place. And of course, they are wrong in saying that, because their own policy tells them that whenever an appeal has been made, if there hasn't been further appeal for permission and there isn't any further evidence in terms of them making an allegation in terms of fraud, or there being any form of deception in terms of the appeal, then they have to implement the decision. So if they have to implement the decision, then it is also their onus, because you have other case laws that say that it is their legal duty to implement the decision of the first tier tribunal. So you have a lot of emails, and you have people who are now saying that because they've received these emails, they don't know what to do. There are some people who are still in the pipelines, because obviously there are so many EA appeals still ongoing that have not received decisions yet. So does it mean that if the appeal is allowed, then it means there is nothing more to do, because of the fact that the Home Office has said they would no longer issue EA family permits? And that is wrong. And so we are obviously saying to people who have had emails, correspondence from the Home Office, which states categorically that they are not going to issue EA family permits, to go and see a lawyer. If you didn't make the application with a lawyer or a solicitor, please go and see one, and then let them, of course, write a pre-action protocol letter. And usually pre-action protocol letters are written as a way of caution to the Home Office that you can issue judicial review. And so if they receive a pre-action protocol letter saying that their decision was wrong not to implement the EA family permit, and therefore they have to, because they have that legal onus or the legal duty to issue such permit or implement such a permit, then of course they will have to look at how they can issue such a permit, so that somebody who is in that situation can therefore make an application, for instance, under the EU settlement scheme. Because as we all know, applications under the EU settlement scheme is still ongoing. So if you want to make an application for a family member outside of the UK, it is still valid to do so under the EU settlement scheme. And so of course, when you even look at our EU settlement scheme, it talks about the fact that the EA family permit is a legal, or should I say, a relevant document that can be used by that family member to make an application under the EU settlement scheme. And so, of course, if you are in this predicament and you believe strongly that you want to fight for this family member to come into the UK, then please do see a solicitor and let them, of course, advise you, and then put in a pre-action protocol letter, which would then make the Home Office aware that you would like to issue judicial review, so that, of course, they know that you are not in any way accepting their decision not to issue. We're hoping that they will also come to the realization that they are also wrong, so that not many people will have to go down the judicial review route, that they themselves will realize that, of course, it is their legal duty to issue the EA family permits to those that have won their appeals. Hence, of course, we are hoping and waiting to see them come up with new guidance in terms of this, because, as I said, there are still so many cases in the pipeline, and so they can't just send emails saying they are no longer going to have EA family permits issued, but they will have to do something about it. And so if they have to, of course, give people the chance to make those EU settlement scheme applications, or they would be willing to issue them with EU settlement scheme family permits, then of course that is also something that we would also welcome. So we are hoping that they themselves will come to that point where they would do the right thing, of course, and then make sure that as many people who are on this route to come into the UK, we all know from their previous guidance that they said EA family permits will no longer be valid after the 30th of June 2021. But it shouldn't be the case that because it is no longer valid, those people who have been allowed to be issued EA family permits should be stuck. They have to have some form of remedy. And so I'm hoping that they will come to that realization. But if not, it means that a lot of people, and I know that there are hundreds, and I'm not even thinking too far, but if not thousands of people will be making these applications to the Home Office for them to consider their decision. And then if they do not reconsider, then it means that people will have to issue judicial review against the decisions that the Home Office have made. And so we're just giving them some time, and I'm hoping that those that are in this predicament will do what they're supposed to do to put a lot of pressure on the Home Office to change their minds about this. So this is just a little update that we have in terms of our EA family permits and those that are currently in the situation of making appeals towards the decisions being made by the Home Office. But we're considering and we're hoping that they would change their minds and look at it in a holistic manner, rather than just the fact that they've made up their minds not to issue it after the 30th of June 2021.
But now, Eunice, is it very common in your experience being a seasoned solicitor? Has there been a time that the Home Office has accepted they are at fault?
Yes, of course. And I think that's why when you are seeing a solicitor in terms of whether you should go for judicial review or not, they will tell you what the pros and cons are and tell you how successful you are to be if you were to issue a judicial review. And usually judicial review is seen as a result if you do not, for instance, have a right of appeal, but you believe strongly that the Home Office have made a decision which is not in line with law. And so if, for instance, the decision they have made is not compatible with our human rights, or it is a decision that is in breach of a person's human rights, then of course you would want to make sure that you have tried to resolve the issue as far as possible. And they know that people will find judicial review expensive. So if there aren't many people who go down that judicial review route, then it means that they are not held to account. But if you believe strongly that you have a case and you go for judicial review, then it puts them on their toes. And so most of the time when you go through judicial review, you realize that they give consent orders, and consent orders is like an agreement between the person who has brought the case to court and the Home Office to say that, okay, so if we are wrong, for instance, the Home Office will say, if we are wrong in the decision that we have made, we will actually make sure that we grant the family permit as you have said, within a period of, let's say, 6 months, or within a period of, let's say, 3 months, and we will make sure to pay all cost. And so they don't want a situation where they are having to go through the court system for the court to then tell them that they were wrong in the first place, when they already know that they were wrong. And that is one good thing about judicial review, because you realize that the Home Office are now coming to where they should have been in the first instance, and they then make that consent order. And so once you find that they are actually willing and ready to, should I say, compromise and basically do the right thing, then you know that you have gotten at least some form of remedy to the problem that was first taken up to judicial review. So it's important that as much as possible, you make sure that you don't leave things as they are. If you have options to remedy a situation, use your options, use whatever you have to make sure that you are putting as much pressure on them as possible, because unless somebody takes up that mantle of saying, do you know what, I want to actually make sure that they are held to account and they shouldn't be doing what they are doing, then of course we wouldn't get the results that we want. So I think that once people realize that judicial review is also a very good way of letting the Home Office realize that they are in the wrong and they need to do the right thing, they would realize that at least they've done all that they could to make sure that the Home Office are held to account, and then they also remedy the problem as it were.
Right. Ladies and gentlemen, if you've just joined us, this is the BWF Legal Hour on Heritage TV. If you want to join us in this discussion, we are live on Facebook at Heritage TV and BWF Solicitors. You can also send us your questions or contributions on all our social media handles. Myself and Lawyer Eunice will be able to pick them up, and Lawyer Eunice will answer those questions. You can also WhatsApp me or call me live on this program on 0744 8619 711. I am your host, Vicky Newton, and with me is the solicitor and partner at BWF Solicitors, Mrs. Eunice Achampon. And we are discussing this afternoon children under 18 applying to join their parents in the UK. Ladies and gentlemen, we're going to just straight away start with our questions for this topic. Eunice, who is a child for the purposes of the immigration rules?
So when you talk about a child, I think that most people, if you have any children, you would say, yes, my child is my child, and regardless of how old they are, they would remain my child. And for me, I'm older. I have my own children, I have my own family. But when I go to my parents, they still see me as their child, and there isn't any age boundary whatsoever. And so when you come to the immigration rules, unfortunately, it is very particular in terms of age. And so that's why the title has under the age of 18. So a child, for the purposes of the immigration rules, is a person who is under the age of 18. Whereas under EU law, or if I say specifically under Appendix EU and formally our EU Regulations 2016, a child, there is no age limit. A child is your child, regardless of how old they are. And so you realize that with EU nationals, they can bring their children, no matter the age, to come and join them here in the UK. So whether they are under 21 or above the age of 21, they can still apply for their children to join them. Whereas under our immigration rules, it is unfortunately not so. It is only limited to children who are under the age of 18, and therefore any person who is above the age of 18 for the purposes of the immigration rules is an adult, and it is so in most of our law. Yes.
Just 1 minute. I don't know whether would you like to pick up calls now, or let's go through the process before picking up calls for questions?
Oh, if the person
just started getting calls.
Oh, okay. If the person would want us to answer something, we can pick up the call. Yeah.
Oh, yeah.
So.
Okay. Oh, okay. So, okay, just go on. He just sends the question via text.
Okay, then.
Yes.
Okay.
Yeah.
So.
Again, me.
Okay.
Yes. Hello, caller. Hello. Hi. Good morning. How are you? Yes. Yes, I can hear you.
So, my question is this, lawyer Eunice. I'm a very big fan of you, not just in general. BWF, very big fan. Yeah, I'm fine. So I made my application 10 June 2021. So I've done my biometric. I've done my biometric July 7. So I've been waiting for either the certificate of application or the section. Still yet nothing. So to me, I'm worried that I feel like I should ask if there's anything I need to worry about.
Okay. All right. Lawyer Eunice.
Yes.
I hope you got the question.
To be very specifically, I contacted BWF to do that application for me.
Okay.
And I think it's a very experienced.
Okay. All right. Okay. All right. Yes. Lawyer Eunice will answer your question. Hold on a minute.
Okay.
Yes, Lawyer Eunice.
So he's asking that since he did his biometrics, he hasn't received the certificate of application. But he's also made mention that yes, he enrolled his biometrics in July. I'm not sure what date in July.
In June.
Oh, okay, in June of this year.
Oh, so he said July 7th.
Okay, so July
7th.
7th. Okay. So usually once a biometric has been enrolled, they would send a certificate of application. They don't have a specific time frame in which they will send the certificate of application, but it usually comes after the biometric has been enrolled. So he should not be too worried. They would send it by email. If it was done by one of us, of course, he can call and then find out if we have received any email to that effect. And I'm sure, of course, that will give his employers some leeway if he's working to let him continue working. And then, of course, if he didn't have the application in the system, there will be no way of him going to enroll his biometrics. So that's a good thing, that at least now that his biometrics has been enrolled, they are considering the application, because one of the ways in which you know that you are making a valid application is once you have also enrolled your biometrics. So not only are they looking to see valid identity or form of nationality, but they also want to know that you have put in the right application and that you have also enrolled your biometrics. So once all these things have been done, he should be rest assured that he's made a valid application, and they will get back to him. It will take some time. It's not very quick. It takes some months.
Okay. Right.
In my own case, I asked the lawyer to use his phone number and his email to address the issue.
Yeah, so the lawyer will get back to you as soon as they get any correspondence from the biometric company.
Okay, but
Yes.
it is EUSS, that's what I applied for under
Yes.
the Irish Bank.
Yes, that's fine. So, like the lawyer Eunice just mentioned, as you've enrolled your biometrics, you shouldn't be worried at all. It takes a while because of the high number of people going in to have their biometrics done.
Yeah.
So just be rest assured. As soon as any correspondence is sent to BWF Solicitors, your representatives, they will be able to quickly give you a call or email you a copy of the email received, and just to assure you that everything is in line. All right? Okay, you're welcome. Have a good day.
Thank you.
Yeah, Eunice. Yes.
Yes.
Right. So where did we get? We were talking about
those under
when
the age
child
of
is-
18. Yes.
Exactly.
Yes. So I was saying how it's different for those that are children to EA nationals or EU nationals who are living here in the UK. And of course, it is good that the EU law sees that a child is a child regardless of age. But under our British immigration rules, it is totally different. And so you have children who are under the age of 18 only being able to apply to join their parents, whereas when they're 18 and above, they're considered as adults, and therefore they have to find other routes in which they can apply to come and live in the UK. So yes, generally, for the purposes of the immigration rules, a child is a person who is under the age of 18.
18. Okay. Right. What are some of the ways by which parents can apply for their children to join them in the UK?
So if you look again at our immigration rules, specifically, you have under our paragraph 297, which is to do with children, and you have other paragraphs after paragraph 297 that involve children and how they can make applications. So some of them talk about children who are applying to join their parents who have indefinite leave or settled status. Some of them talk about children who are applying to come and join their parents who may have leave to remain in the UK. Some of them also talk about children applying to come and stay with their parents who may, for one reason or the other, may, for instance, have adopted them. And so you have different categories under our immigration rules that deal with children applying to come into the UK. But to talk directly to our parents who, for instance, are British or have settled here in the UK and have indefinite leave to remain, and those that, for one reason or the other, may now have leave to remain, which is 2.5 years leave to remain. And so you find that under our Appendix FM, it talks specifically about those parents who only have leave to remain or 2.5 years and would like for their children to come and join them here in the UK. Whereas under our paragraph 297 and onwards, it talks about parents who have settled status or are British and would want their children to come and join them here in the UK. And so parents who, for instance, may be living in the UK and for one reason or the other, let's say we have a British citizen here in the UK and maybe they're applying for their spouse to come and join them, and that spouse will be given leave to remain, and then the child will also be given leave to remain in line with what their other parent has. So there is that route. Then you also have both parents living here in the UK who may have settled status or who may be British. And so, because of that, they now believe that it's time that they invited or made the application for their children to join them. And then you also have people who may, for one reason or the other, be the sole parents in the UK, looking to meet their child's need wherever they are. And so they would like that child to come and join them here in the UK. And then you also have parents who, for one reason or the other, may have leave to remain. So they only have 2.5 years leave to remain, but they would like for their children to come and join them here in the UK. And then you may also have a relative who, for one reason or the other, because this child who is a family member has now come to live within the family household. They've looked after this child for a very long time. And unfortunately, the parents of this child may have abandoned the child long time ago or may have passed away. And therefore, this child only knows this relative here in the UK. And if that is the case, they can also apply for that child to come and join them here in the UK if they can show that there are very compelling and factors or family considerations that are to be considered. And if the child is not allowed to come and join them here in the UK, of course, it will be very detrimental to that child's upbringing. So you have these different categories of parents or relatives that can apply for a child to join them here in the UK. And you also have to be able to show that the child is under the age of 18, that the child, of course, is outside of the UK, that the child is not living an independent life. And so when they say independent life, that the child is not having their own family life outside of their parents or their relative. Yes, and maybe they don't have any children, they are not married, they are still very much dependent on their parents. And so that is not living an independent life. And then when it comes to the child as well, of course, you're showing that this child will be maintained by you, the parent who is here in the UK. So when they talk about being maintained, they don't want this child to fall back on the States. They want you, the parent, to show that you are financially capable of taking care of this child. And usually that's where they consider the income or the salary that this parent has, and whether it will be able to meet the income support rate that they give to children and single parents here in the UK. And they also want to know that the child will be accommodated suitably. So they want to know that the living conditions under which you live in is suitable enough for the child who is coming to join you here in the UK. So if you are able to show all these things, then it helps whoever is making the application, considering the application, to know that you are more than capable of looking after this child when they come and join you here in the UK. So those are some of the routes, or those are some of the ways in which a person can apply for their child to join them in the UK.
Okay, hold on 1 minute. Okay. What is your name and where are you calling from? Okay, Kwame. Lawyer Eunice is here to hear your question. Go on.
Okay. I think my wife applied for an extension of 2.5. I got her to the UK 2018, and her 2.5 was supposed to expire, I think, next month. So we did the extension, we applied, but the financial requirement is the threshold. I did not have any document concerning my wage because she too is working and she's any more than the age threshold.
Okay.
So I asked her to receive an advice that she too can use her financial statement and everything to put that financial bill of it, which we did. I just recently, I think yesterday, we got an email from Home Office that they said the sponsor needs to declare the part 2 and the part 3 of the form. We should declare on that form. Now, when I check on the part 3 is about the financial, I think that's about the financial support.
Okay.
Which I do not support her financial concerning that aspect. So we decide that part 3 is me, which brought her in.
Who is the sponsor? Okay.
Yeah, so the question I want to ask is, is it me who's supposed to sign it, or she put her financial everything about her, the financial this on the form. She did it, so it's her who have to sign, or it's me who have to sign.
All right, Lawyer Eunice will answer your question now. Hold on.
Okay, so in terms of the financial support, if you look at our immigration rules, when you're meeting the financial requirement, it's not limited to just the sponsor. So, of course, both the applicant and the sponsor can show that they meet the financial requirements. And if the applicant can show that they can meet the financial requirements on their own, then of course that is also valid in itself. So if they are asking you to complete part 2, they are not necessarily saying that because you are providing some sort of financial support, so you have to complete part 3. So for instance, let's say that because of the fact that your name is on a bill, so let's say council tax bill, and so because your name is on the council tax bill together with your spouse, they will say that if you have your names jointly on any document, please complete part 2. So because your name is on that other document, which is the council tax bill, for instance, you have to complete part 2 of the declaration page. And then in terms of part 3, so for instance, you've added your copy of, let's say, an itemized bill. It is not necessarily you and your wife's name. It is just your name, which is on that part of the bill. And so because they want to have that consent to verify the details on that bill, they will ask you to complete part 3. So don't just see as because you are not providing any financial support, and that's why you don't see why you should complete part 3. If your name is on any form of document to which she has presented to the Home Office as some supporting document to her application, they will ask that you complete part 2 and 3. So don't just see it as limited to financial support. Yeah.
Okay. So which means if I sign the part 3 as well, you're not going to like anything.
No. It's just to say that because your name is on a document, they can verify it.
Was that the 2 years supporting this that I have, and it was both on different names. My name was separate and her name was separate. So I do not have anything joint name. That's why
yeah.
We'll have to sign on it. So that's
yeah.
Okay.
All right. Thank you for calling. Have a good day.
All right.
Yes, well, Eunice, as regards to this question from this gentleman, so if the sponsor, let's say he's also earning that 18,600 threshold, and he decides to add his, bank statement whatsoever to the partner.
Yeah.
Can he do that or at the moment, because she is earning that 18,600 threshold, he decided not to add his. But can he add it if it's another person? Will it change anything?
Of course, it wouldn't change anything if he decides to add his pay slips and bank statements. So if, for instance, the applicant in showing that her pay slips and bank statements and the required employment letter shows that she earns more than the 18,600 that they've requested, then of course the Home Office will know that from her supporting documents alone, she's able to meet the threshold. If he decides to add his pay slips, bank statement, letter from employment, it doesn't really spoil anything. It just goes on to show how they are exceeding the threshold which the Home Office have stated. So it really doesn't spoil anything at all.
Eunice, I've got a question here coming from Anna. Says, I have 2 children in Nigeria who are both under the age of 18. I now have my indefinite leave to remain and would like to bring them to join me in the UK. The children live with my mother as their mother abandoned them 5 years ago. What do I need to put in the application?
Okay. So you have here a classic case of a parent who is now here, settled here in the UK, and they want to bring the other child. And here is the case that the other parent is obviously gone AWOL. So they don't know where the other parent is, and they are the ones who have looked after this child for that period of time. And he says he's looked after this child for at least 5 years. If that is the case, then of course, he will need to show that as much as possible that this child is his child. So usually when we say that you have to show evidence that the child is related to you, of course, the birth certificate is the first thing that comes to mind. But we realize that a lot of the time when these applications are refused, they always mention the fact that the birth certificate was not within 12 months of the child's birth, and therefore, considering studies that have been done, they are not sure that the birth certificate is genuine and the rest of it. So just to put their minds to rest, we just tell clients, do you know what? Maybe it's better that you do a DNA report so that they know that this child is indeed related to you. But apart from the birth certificates, there are people that have good record keeping and they have evidence of things like the weighing book, which we call the child health record book. And then they have evidence of certificates like baptismal certificates and other things which show the time the child was born and the parents to which the child was born to. And so, of course, if you have things like that, they can help. But if you don't, and you are somebody who hasn't got a record of all these things, then it's always best to put the DNA evidence forward so that they know for sure that this is your child, as you say. And then, of course, once you have shown them evidence that you are related to this child, you should be able to show them that, of course, this child is very much dependent on you. And in most cases, if you are applying as a settled person to bring your child here, they would also grant the child the same settled status that you have. So if you have indefinite leave to be in the UK, they will grant that child indefinite leave to indefinite leave to enter the UK. And so, of course, once you are able to show that you have that status, so this could be your passport Some people will also have it on a biometric card. You can also present that as evidence. And then you also want to show that this child is very much dependent on you. And if you look at paragraph 297, it talks about the fact that you should be able to show that you have sole responsibility for this child. And the way that you are able to show that you have sole responsibility is by also evidencing that the other parent is not playing any role in this child's life, and you are the sole carer of this child. And so, how do you show that? It's about you showing evidence that, of course, you play a role in this child's life. If you are saying that somebody else is taking care of this child whilst you are here in the UK, then who is that person? Is that person another family member? That other family member may want to also swear an affidavit to say that they receive specific instructions from yourself in regards to the child's day-to-day living. So if important decisions have to be made in terms of the child's education and the child's health, you are the one who tells them what to do in regards to that. And so even regarding the school the child will attend, you make that decision. You are the one who pays the fees. You are the one who checks on the child's progress. If the child is not feeling well, that person informs you, and then you, of course, tell them what to do in terms of that child. And so that person can swear an affidavit to that effect. And of course, schools keep very good records. So if you are saying that you are somebody who checks on the progress of the child and you have made contact with the school, they will have a record of the fact that Mr. So and so is a racist father, or he's Bole's father, and therefore he has contact with the school. He's always checking on the records to see how well the child is doing. We sometimes send in emails about the child. We make sure as much as possible, we make him aware of what is going on in terms of the child's end of year exams and the rest of it. And we do not have any contact whatsoever with the mother, apart from, let's say, the grandmother who is looking after the child. So if it's the grandmother, they know they will put that in the letter as well. If they have no contact whatsoever with the mother, they will put that in the letter as well. So that is also one of the ways in which you can show that you are the one who has sole responsibility for the child and not the other parent. Some people may even go as far as getting a police report to say that they have tried making searches for the mother, but to no effect. So they still have no record of where this child's mother is. So you can present those things as evidence. If you have good contact with, for instance, the hospital or the clinic where the child usually goes, they can also write a letter to that effect as well, in terms of the child's health and well-being. If you have receipts from the school to show that you pay the school fees, you can also have that as evidence as well. So school fees receipts also help very much in terms of showing that you are financially responsible and supportive of this child. And of course, if the child is old enough and they have their own phone and you sometimes communicate with them, you can present your communication in terms of your messaging or your phone call history as also evidence that you are somebody who has emotionally bonded with this child. And if it's the case that you are calling this child through the grandmother or the third party, then of course you can also show that sometimes from time to time you have WhatsApp video calls. It's not just phone audio calls, but also you have video calls with this child. And you know how technology is. You can always do screenshots whilst you're talking to them, just to show that you have evidence of this as well. And so There are a number of evidences that you can include with the application to show that the child is solely dependent on yourself and no one else. And if it is the case that you can also accommodate this child and you can maintain this child, you add your pay slips. There's no required number of pay slips or bank statements you have to add, because it's just to show that you can meet the income support rates that they give to children here in this country, which is the UK. And then you can add your tenancy agreement, or if it's a mortgage, you can add your title deeds, mortgage statement to show that you have more than enough space for this child to come and reside here in the UK. So all these documents can be presented in terms of the application. And if you are in a country where they are at risk of tuberculosis, you definitely have to have the child be tested for pulmonary tuberculosis, which is also another requirement under our immigration rules. So you also have to include the TB medical certificate that this child has been tested and there has been no defect, or there has been no trace of tuberculosis in that child. So these are some of the documents that they can present in terms of making such an application for the child to join them here in the UK.
All right, great. Yes, ladies and gentlemen, if you've just I've seen people on social media just joining in halfway through the show, but don't worry, this program will be available on our Facebook pages at Heritage TV and BWF Solicitors, and you can have time to just listen to it from beginning to end. So don't worry about that. But if you still want to stay with us through to the end of this live program, then just to let you know, today's topic is children under 18 applying to join their parents in the UK. And with me is a seasoned solicitor and also a partner at BWF Solicitors, Mrs. Eunice Achampong, who is here to discuss this topic with us and also take all your questions on this topic. As usual, I'm your host, Vicky Newton. Lawyer Eunice, I've got another question from Fumi. She says, my husband and I both have limited leave to remain and have a daughter in Ghana we would like to bring over. We have been in the UK for over 15 years, and I found it difficult to go and visit her because of the two other children we have in the UK. We both keep in contact with her school and communication. Pardon me. We both keep in contact with her school and communicate with her almost every day. Would it be an issue if we haven't gone to visit her?
Okay, so I think most people who may have to and have will be in this predicament because you haven't got leave, you haven't traveled outside of the UK because you haven't regularized your stay. Eventually, when you do regularize your stay, you have other responsibilities in terms of the children, and therefore you still have not been able to make the trip because, for instance, the money you're earning is not enough to take care of the family and also buy tickets for yourself and the children to travel outside of the UK. So it becomes very difficult for you to then travel. And it's just, should I say, the cycle in which most parents find themselves. And so when it happens that way, it's one of those things that I always say to parents, that you don't really have to worry so much if you haven't been able to go and visit the child. As long as you are showing to them that you have been responsible for this child, since, of course, you, let's say, left them, or since you obviously decided you'll be well enough to be able to contribute towards their schooling and the rest of it, then of course there isn't any, should I say, financial requirement in terms of you showing how much money you give to that child. And there isn't any requirement in terms of showing sole responsibility if both parents are here. There isn't that strong requirement to show that you should show that this child has depended on you for this number of years. It's basically showing that both parents have leave to remain here in the UK, and you can adequately maintain this child, you can adequately accommodate this child when this child joins you here in the UK. So if you are able to show these things and you are saying that, hey, this is our child, of course, and we have tried as much as possible to communicate and show that this child is dependent on us. Don't worry so much about sole responsibility, because that doesn't come in at all. So there isn't that pressure of showing that, because both parents are here in the UK. And if they are working, they will show evidence of their pay slips, show evidence of their bank statements, and the letter from employer to show that they can adequately maintain this child when this child comes. So apart from the 2 children that they have here, the 3rd child coming in, if they have a combined income which shows that they are more than capable to meet the maintenance requirement or meet the income support rate that they give to children and parents here in the UK, that should be good enough. And if they can also show that they can accommodate this child when the child comes, that in itself should be fine. So those are the main things that they are looking at if both parents are present here in the UK, whether they can show that this child is actually their child, whether they can show that they can accommodate, whether they can show they can also maintain this child when they come. So of course, it shouldn't be an issue whatsoever if you cannot show that you have gone to visit the child at all.
Okay. Yes, caller. I think you called not too long ago. Do you have any other questions?
Yes. I want to ask about this UAN number that starts with 3434. What does it stand for? Because I've got that. If I can use that to apply for my national insurance number, please.
Oh, okay. So the UAN number is obviously the unique application number, and it is also the Home Office reference number for your application. In terms of applying for national insurance number, unfortunately, once you go onto their web page to complete the application, they would either want you to show that you have your valid biometric card or immigration status. So that Home Office reference number is not sufficient in itself to help you apply for NI, unless you have been granted your settled status or pre-settled status. So you would have to wait for a decision to be made before you apply for your NI number.
All right.
Okay.
Thank you very much.
You're welcome. All right. Okay. Thank you. So Lawyer Eunice.
Yes.
So on this gentleman's question, so what if because we don't have any time frame of this biometric being sent to this gentleman?
Yes.
As proof of ID, right? And he needs to work. And without that national insurance number, he cannot get work.
Yeah.
So how does he go about,
doing
trying to do something, to look after himself. And his family?
I think that's
still go and look for work without the NI.
That's obviously in terms of, voluntary work. So if, for instance, he's doing some voluntary work and somebody is saying to him, I can't pay you a salary, but I will give you something for your work that you do, then of course they can do so. And the difficulty in terms of making these applications and then not having any fallback in terms of how to make an application for NI is something that a lot of our clients who are making these pre-settled applications or limited leave to remain applications would usually find themselves if they previously did not have leave in the UK. So if you have somebody who didn't previously have leave to remain in the UK, and this is the first application they are making, they would usually find themselves in this predicament because you were here illegally, and it's considered that you are still here illegally until you are granted leave to remain, or you are granted pre-settled status. So unfortunately, that's the situation in which most of our people may find themselves in because they don't have previous leave to rely on. It would have been a different situation if he had leave formally, because of course then you are just saying to the employer, I put in my application before my leave expires, so it is as if my leave never expired. Whereas in this situation, because there was no leave previously, he would just have to wait and bear with it until they make a decision on the application.
Okay. Right, another question is coming, and this person doesn't wants to remain anonymous. I have a son back home, and his father recently passed away. Since then, I've had to take him to live with my sister and her family temporarily. I communicate with him through my sister and send money to my sister for his needs. I visited him 2 years ago, and I'm wondering if the money transferred receipts and travel itinerary will be enough to make the application.
In terms of making the application, you definitely need more than money transfer receipts and communication itineraries. Of course, if he's been to see this child, it's a good thing because, of course, it shows that they have some bond. The communication also shows that they obviously have some attachment. So they talk to each other. There'll definitely be questions that this child will ask, and there will be things that maybe will be on that child's mind that they will want to find out. And so these things may come through communication. Of course, if the parent is not used to messaging, then it means that it would usually be through phone calls, and sometimes that is measured in the times or the number of times that the parent or the child will call each other. And so if they usually call each other every day, that will obviously show through the phone call itinerary or phone call history that they present as part of the application. And then when you're talking about this parent specifically, because they're saying that they now live with his sister, and so the death certificate of the mother should definitely be presented. And so that in itself will show that this child's mother is no longer alive, and the only parent that this child is able to rely on, is able to depend on, is themselves. And so, of course, if the other parent is no more, that takes away the pressure of showing sole responsibility, because there isn't any parent in the first place. So it means that the other parent who is here in the UK has to take on that responsibility to look after that child. And so if you are making the application, definitely you have to include the death certificate to show that the child's mother has passed away. You also have to show, of course, that that child is your child, either by way of the birth certificate and child health record book, or you will have to have a DNA test done to show the relationship. And then, of course, you present your documents such as your passport, and if you have a biometric card, your biometric card, Passports always show stamped areas when you travel, so it will have record of when you travel to see your child. The child's passport will definitely be one of those things that will be presented to show that this child is showing some valid form of identity and nationality. And then, of course, you are also saying that when it comes to showing that this child is very much a part of you, the other evidences that he's mentioned will go a long way to help. And then, of course, they would have to show that as much as possible that they can accommodate and maintain this child when this child comes here in the UK. And then, of course, add the TB medical certificate, and that should suffice in terms of showing that that parent is making the application for this child to join them. And so, once you've added the death certificate, it removes that evidence of showing that you are solely responsible for this child. So, yes, they can go ahead and then add those things to the application as well.
Okay. The next question. Right. This is a question from Muni. My sister's son has lived in our family home for the past 5 years, and the child's father did not play any role in his life since he was born. My sister was seriously ill and eventually passed away. I want to bring the boy to come and live with me, with my family in the UK. How do I go about it? Father is absent and mom suddenly passed.
And this is not your typical parent and child scenario. This is a child living within the family household. So this is what we call the extended family member. And so, of course, this child has been living in the family household, and he's being maintained by his uncle here in the UK. And so, of course, if it's his uncle maintaining him and looking after him and supporting him, then it makes sense that he might as well come and join his uncle here in the UK. So, of course, he says the child is also living with the sister and her family. So it means that it can't be a permanent thing if the sister's husband, for instance, doesn't want the child living in their home forever and ever. As much as we would like to think that we are very communal people when it comes to our African background, because our culture is such that we look after each other, but it is not always the case that the other person that you're married to would want that to be a permanent thing. So when it happens like that, it's one of the family members that has to take responsibility. And since he's the man, he's decided that he will take on that responsibility and let the child come and join him here in the UK. And so in so doing, when you look specifically, for instance, at our paragraph 297, it talks about a relative also showing that they have settled status and then making the application for this child to come and join them indefinitely here in the UK. And so if there are compelling factors or family considerations which will make the exclusion of this child undesirable. So if, for instance, we were saying that because of those compelling factors, the child should not be prevented from coming to live with his uncle here in the UK. So yes, they've been able to show evidence that the child is related to the uncle, as he has said. They are also showing that, of course, this child has nobody else to depend on apart from this uncle here in the UK. So this uncle is showing evidence of money transfers that he gives to the sister. So of course, He's got those money transfers. He's got itineraries to show that he communicates with this child. And then you also can have the sister do an affidavit to say that, do you know what? My family and I have our own responsibilities and our own pressures in terms of finances, and we cannot afford to look after this child. And that is why my brother, who is in England, for instance, has taken up this responsibility of looking after this child, and he pays for his school fees. He's always communicating with him. The school knows his uncle in the UK. They also know that, of course, he's doing whatever he can to support this child. And so we make sure that as much as possible, whatever my brother sends for his upkeep, we use it for his feeding, for his clothing, and for the rest of the things that he needs. Of course, if the accommodation is also unsuitable in terms of living space, they can also mention that maybe living conditions are not good enough. They are struggling in terms of even beds and the rest of it. And so it's important that this child also joins the uncle in the UK. So they can, of course, put all of this into writing in terms of an affidavit. And then if it is the case that this uncle has been to see this boy, then of course, not only is he showing the stamps in the passport, he can show photographs, he can, of course, show those communications with the child whilst he was there to show that, of course, him and this child have bonded in a way that he thinks that without his support, this child will not be able to grow and function and be that good adult or citizen that will contribute to society. So it's important that, of course, they are able to show all of these things in terms of the application that he will be presenting. And if it is a case that he can show that he's the one who has custody of this child. So most of the time it's good to get some form of court order if, for instance, you were saying that the parents of the child are not there. So if the mother is passed and if the father is somebody who hasn't played any role whatsoever in the child's life, then it becomes essential that you get some sort of court order to also basically confirm those facts. And that's why it's always good when you are not the actual parent of the child to have some sort of custody order to say that you are the one who is ultimately responsible for keeping this child as well, and you are the one who is responsible for this child. So that in itself goes a long way to establish the responsibility that you have for this child. And when you're making the application, once you are able to include all these other evidences, then of course you know that the application stands a strong chance of being successful, because at least you've been able to show that there are compelling factors or family considerations that will make it very difficult for them to say they would refuse this child from coming to join you here in the UK when you are the only person that this child looks to, and you have that bond with this child that you really want to impact this child's life, so that of course they too know that they have somebody who cares about them. So yes, in terms of making that application, they can go ahead and then obtain those evidences and then make the application.
Okay. All right. I think I'm done with my questions at the moment.
Okay.
I don't know whether you got any on the BWF Solicitors platform.
Okay, so this one says that It's from Ezekiel Johnson. It says, "Hello, lawyer. Please, there is a seaman originally from Ghana. He came to the UK on a contract to work with a UK vessel. He has been based in the UK of he has been based in the UK working with the company for the past 9 years. Is there any route for him to get residence in the UK, please?" Okay, so in terms of making this application, of course, this person who is now a seaman would definitely have needed some form of residence if he wanted to reside here in the UK or stay here in the UK. And if his vessel is also a company that is registered here in the UK, then I would say that it will be better to find out if that vessel is also a sponsor. So if the vessel is a company that's registered here in the UK, then they can apply for a sponsorship license. And a sponsorship license is basically one that will allow the company to be able to apply for a work permit visa for any employee that is outside of the UK. So if for one reason or the other, this gentleman who is a seaman can find out from the company whether they are registered in the UK, are they also a licensed sponsor, are they registered as a sponsor on the UKVI register, then of course they can apply for a work permit visa. It should also be the case that the work that he's applying for, I'm not sure whether seaman is one of those eligible occupations, but it has to be something that is an eligible occupation under our list of skilled workers. So if he does find that he's able to apply and his occupation is one that is considered an eligible occupation, then he can apply for a work permit visa, or what we now call a skilled work visa. So, of course, there is that option. And then there is the option of family. So he's lived here for 9 years. If he does have any family in terms of wife or partner or child who is British or settled here in the UK, they can also apply to reside here with the spouse or with the child or with the partner, if they are able to show that they are going to be able to meet the requirements. So if they are applying from outside of the UK, then of course it will be the fact that they should be able to show that they are in a genuine and subsisting relationship with the spouse or the partner, and that they obviously can meet the English language requirements. They will be able to show that their partner will meet the financial requirement of 18,600. And of course, if they are showing that they will be accommodated, then of course they should be able to show that they can be suitably accommodated here in the UK. But if it's because he's currently here as a seaman and his vessel is currently here in the UK and he wants to make the application from the UK, then he should be able to show that requirements under EX1. So if there are certain requirements he doesn't meet, so he doesn't have leave. So he's saying that because he doesn't have leave, he will be able to show that he has a genuine and subsistent relationship with a child, and therefore it will be unreasonable for that child to leave the UK. Then, of course, he should be able to show that he has some parental responsibility for a child who is either British or who is settled or who has lived here continuously for a period of 7 years, like we were talking about last week. So if they can show that the child is not British and is not settled, but that child has formed private life here in the UK and has lived here for a continuous period of 7 years, then they can make the application and then say that because of that parental responsibility they have for that child, it will therefore be unreasonable for that child to return or leave the UK. And in so doing, of course, once they are able to show that, then they can grant them further leave to remain in the UK. Of course, if they have no family members, then it falls on the fact that they have to have lived here for a continuous period of 20 years before they can make an application. So they have these options available to them if they do want to make an application to reside in the UK.
In the absence of any further questions, is anybody watching us who would like to contact you after the show if they have any further questions or concerns? You could please give us your details and how to get in touch with you after the program.
Okay. And so, yes, in dealing with today's topic about children who are under the age of 18 applying to reside in the UK, I know that dealing with this topic during the week, a lot of people made inquiries and people would want to make such applications. And so if you are one of those who would want to make further inquiries, and then if you have any other issues apart from the topic that we discussed today, please do not hesitate to contact myself. And my number is 075 3581 3910. And as Vicky said, I do work with BWF Solicitors. I am one of the solicitors there, and we are situated in London. Our address is the 4th floor of Anna House, 214 to 218 High Road, London, and the postcode is N154NP. So it's N154NP. And our office telephone number, as we are usually open from Monday to Friday, from 9:30 a.m. to 6 p.m. Our office telephone number is 0208 493 7340. So 0208 493 7340. So yes, please do not hesitate to contact us if you do have any further inquiries or you would like our assistance in putting in an application.
Well said, Lawyer Eunice. Thank you so much for your time, always making time out of your busy schedule to come to us or come our way every Saturday from 12 noon to educate us. And let me take this opportunity to give my announcements before we say goodbye to the show. BWF Solicitors also have a community and the law program on Saturdays from 4 p.m. It's live on Facebook, so if you want to, join in this program, feel free to, jump on at 4 p.m. at BWF Solicitors Facebook page. Today's topic is, why is the Home Office and UKVI refusing to issue EEA family permit even when appeals have been allowed or applications made before the deadline? The topic again is, why is the Home Office and the UKVI refusing to issue EEA family permit even when appeals have been allowed or applications have been made before the deadline? So if you are very interested in this topic, at 4 p.m., just jump on your Facebook page, BWF Solicitors, with host Mr. Urugu Frempong and one of the seasoned solicitors from BWF Solicitors. It is not Lawyer Eunice, but it is Mr. Patrick Murai, who will be, discussing this topic with the host. So that's another information. My last announcement is the Croydon Children's Club based in Norbury. If you live anywhere around the SW area, the Croydon Children's Club are having at their open day. It's a nursery from 0 to 5 years, Ofsted is inspected, and they've been in existence for over 20 years with very qualified staff. They're having their open day. If you are around that area in Norbury, postcode SW164LF at 273 Norbury Crescent, pop in and have a look around and meet the lovely staff there. It's the Croydon Children's Club nursery. On that note, ladies and gentlemen, have a lovely day, and I hope you join us same time again next week with another interesting topic. And my great gratitude and thanks to BWF Solicitors, one of our sponsors, Victor Estates Limited, and Eagle Heights International School. We very much appreciate all your support. Yes, I don't know. Laura Eunice, are you there?
Yes, I am.
Okay, so I've said what I have to say and my thank yous. I think I will just leave it with you to, give us your last word and say bye-bye. We are just swapping. So I will just end it all and, say goodbye to the viewers.
Yes, so our viewers should enjoy the rest of the weekend, and hopefully we will see them same time next week.
Goodbye.
Bye.
All right. Now, you did very well. So, ladies and gentlemen, take care. I will see you next week. Bye.
At BWF Solicitors, we take pride in our client service as a niche law practice. We are conscious of the demands of our clients. We always offer a friendly, listening ear and sympathetic attitude. We've worked with thousands of people all across the UK in all areas of personal legal services. We have received great feedback and reviews from our clients. We are located at Solicitors in Tottenham on the 4th floor of the Anna House, right on top of the Victoria Line train station, where utmost convenience. We have a friendly office and provide all of the refreshments necessary while you wait to see a lawyer. We are dedicated to our clients and have a successful record of serving our clients. Solicitors of England and Wales are of high quality and are bound by the highest professional standards. We are officers of the court and are bound by standards of integrity, competence, and conduct as part of our responsibility to uphold the rule of law. Our solicitors and lawyers care about your case and are committed to providing the best possible service to you in the most considerate and careful manner. We hold 2 Law Society quality marks, Law Society Accreditation House, to demonstrate that we have attained the requisite standard in the area of law and have the requisite expertise. We of solicitors are here to help you.